Bismillah ar-Rahman ar-Rahim. In this session, I will lead you to the summary of the main cases which are recommended for HEC law GAT. So the first case is Maulvi Tamizuddin Khan case that was decided by the Federal Court of Pakistan in 1955. So in the constitutional history, this case was very important because during that time, Constitution was in the process of being made. So the parliament was both the parliament as a legislative assembly, and it was also assigned the task of making a constitution. It was also a constituent assembly. So what happened that the Governor General of that time, Ghulam Muhammad, was in a tussle with the parliament. So Maulvi Tamizuddin, who was the president or the speaker of the assembly, he challenged the proclamation of emergency, which had dismissed the assembly by the Governor General before the Sindh High Court. The question before the court was whether the relevant section of the Government of India Act, which invested the courts with this power to issue writ against the Governor General, was valid or not valid. The Sindh High Court decided in favor of Maulvi Tamizuddin Khan, asking that the writ of mandamus, which restrained the government from interfering in the exercise of his functions, was valid. However, on appeal before the federal court, that will later become the Supreme Court of Pakistan, reversed the judgment of the Sindh High Court on this technicality, that the section under which the writ was issued was not a good law because it had not yet received the assent of the Governor General. So this was a seminal constitutional case which paved the way for later cases such as the State versus Doso case. This case was decided in the context of the imposition of first martial law in Pakistan by the Chief of Army Staff at that time, the Commander of the Armed Forces, General Ayub Khan. The Supreme Court, led by Justice Munir, upheld the order of the martial law administrator on the basis of Hans Kelsen's famous theory of pure theory of law. The validity of 1955 order and the legitimacy of imposition of martial law was then called before the Supreme Court, and the Supreme Court said that yes, so a new order has established and its legitimacy comes from its success. So a revolution, if it's successful, it becomes the norm creating body in itself. This is how the Doso case was decided. Then we move on to the famous Miss Asma Jilani case that was decided in the aftermath of the secession of Pakistan. What happened that in 1969, General Ayub Khan, rather than following his own constitution, 1962, that he wanted to, instead of transferring power to the Speaker of the Parliament, power was grabbed by another general, this time General Yahya Khan. So Malik Ghulam Jilani, who was a politician from Lahore, was arrested and placed under preventive detention under the Defense of Pakistan rules. The Lahore High Court dismissed the constitutional petition against the detention of Mr. Jilani, relying on Doso case. And then the case was brought before the Supreme Court. The precise question was whether the High Court had jurisdiction under the 1962 Constitution to inquire into the legality of the detention of Mr. Jilani under the martial law regulation that was issued in 1971. The Supreme Court held that Hans Kelsen's pure theory of law, as relied upon in Doso's case, was by no means a universally accepted theory of law. The court held that the Grundnorm of Pakistan was not the successful revolution, but rather the objectives resolution, which confers sovereignty on Allah Almighty alone As a result, the martial law regulation was struck down, having been made by incompetent authority. And then Pakistan had another martial law, this time by General Muhammad Ziaul Haq, who imposed his martial law in July 1977. The 1973 constitution was set in abeyance. It was not abrogated. It was simply suspended for the time being. Zulfikar Ali Bhutto was arrested and detained, and his wife Nusrat Bhutto moved the Supreme Court against his detention as infringement of fundamental rights, relying on Asma Jilani case. The Supreme Court, however, dismissed Ms. Nusrat Bhutto's petition on the basis of doctrine of state necessity. So Hans Kelson's pure theory of law based on successful revolution now got another resurrection, another birth in the name of doctrine of state necessity. It means that the dictum laid down in Ms. Asma Jilani case was overruled. Then another revolution happened in October 1999, but before that, something important took place. And that was the tussle between the Prime Minister Nawaz Sharif and the President Ghulam Ishaq Khan. And Ghulam Ishaq Khan, relying on Article 52B of the Constitution, which was inserted into the Constitution by General Ziaul Haq, dissolved National Assembly on the basis of charges of corruption, maladministration, and nepotism. Sound very familiar. So the deposed Prime Minister filed a constitution petition before the Supreme Court under its original jurisdiction under Article 184, sub-Article 3 of the Constitution. The Supreme Court, headed by Justice Naseem Hassan Shah, in contravention with its history, where it had previously sided with the executive, but that executive was most of the time military executive, restored Nawaz Sharif's government, and the president's action was declared unjustified and unconstitutional. Then we have a famous Al-Jihad trust, where judiciary and legislature or the executive were packed against each other. So what happened is that Benazir Bhutto's government wanted to appoint certain judges, which did not find favor in the eyes of the sitting Supreme Court judge, Supreme Court Chief Justice of Pakistan. So the Supreme Court granted leave to appeal against the appointment of 20 judges to the Lahore High Court to consider the constitutionality of such appointments during Benazir Bhutto's second government. While accepting the appeal against such appointment, the Supreme Court laid down these principles: that the appointment of ad hoc judges violates the Constitution, and acting Chief Justice cannot be a consultee for the purpose of appointment of judges. The senior-most judge of the High Court has a legitimate expectation to be considered for the appointment of Chief Justice. There should be effective consultation between the consultee and executive regarding judicial appointments in the constitutional courts. And as you see that the debate has moved on, but this debate about the appointment of judges remains at the very heart of political governance in Pakistan. Then in October 1999, another coup happened. This time, General Pervez Musharraf proclaims emergency and appoints himself as the chief executive, as if the country is a corporation and he's the CEO. Again, the 1973 constitution is suspended, and his actions are challenged before the Supreme Court, and lo and behold, Supreme Court reinvents the doctrine of state necessity. The court also authorized General Pervez Musharraf to amend the constitution. And here the point was that even Supreme Court cannot amend the constitution itself, but Supreme Court grants this powers to the general. But with the proviso that fundamental rights should continue to hold in the field, and the court will have the power to review executive authority. So that was the dictum laid down in Zafar Ali Shah case. Then we had Asfandyar Wali's case in which NAB ordinance was challenged before the Supreme Court because this law grants wide powers to the executive to detain people, to deny them grant of appeal. And NAB is a kind of very interesting organization. It has its own jail, its own judiciary, its own enforcement mechanism. The Supreme Court very boldly said that it has the authority to review any law and declare it wholly or partially invalid. However, in this case, they did not exercise this power because the general was there and they were definitely afraid of losing their jobs, but they still kind of indicated to the executive that they may exercise this authority. But in this case, they asked the executive to please reconsider and amend the law if possible. Okay, so this was the summary of the cases that we wanted to discuss, and those were the recommended cases. Now we move on to Professor Beata Pollock, who will give us an overview of international law. Thank you, Beata, for joining us.
Hello. Once more, good morning or good afternoon, actually. Let me share the screen. I will start with the UN Charter. I don't know, I hope it's, is the presentation visible? I'm sorry, I'm
yes,
not,
it is. Yes, it is.
Yes. Okay, great. The UN Charter was establishes purposes, governing structure, and principal organs of UN. UN Charter was signed in San Francisco in 1945 by 50 of the 51 original members countries. At the time of the San Francisco conference, Poland was one of the original signatories. Right after war, was going through a very difficult phase. What was taken over by communists. We didn't have our own government. Therefore, we signed the charter a little bit later, but we are still being treated as the original member countries. UN Charter consists of a preamble, 19 chapters, and 111 articles. We will not go today through every article because everyone can easily read it yourself. We will analyze today a few selected, I would say, more important articles. But of course, each article is important, and each article has its legal implication. In the preamble, we can find the reason why UN was established. So we can read. We peoples of the United Nations determined to save succeeding generation from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind. We all know that UN is a successor of another organization, League of Nations, which was created after First World War. As we all know, the League of the Nations was not a success also, and could not fulfill its main function, which was to maintain peace and security. And then Second World War happened, and then we all know what a disaster it actually was. It actually shows us that during the war, people are unpredictable and how inhuman war is. Holocaust, ghetto, concentrate camps, gas chambers, Russian gulags, which were same as Nazis concentrate camps, Hiroshima, Nagasaki. This is all what remind us how cruel the Second World was. But anyways, we can talk about the Second World War for really long time, because quick reminder, Second World War started 1st September 1939 in Poland, when Nazi Germany attacked our country, and 17 days later Soviet Union. But I think today we should talk about the UN Charter. So Article 1st state the purposes of UN. Let me. Yes. So in the article 1st, we can read that the purposes of UN are to maintain international peace and security, to develop friendly relations among nations, to achieve international cooperation in solving international problems, economic, social, cultural, humanitarian, to encouraging respect for human rights and fundamental freedoms. And UN should also serve as a center for harmonizing the action of nations. Article 2 establishes the principles of UN, which are inter alia sovereign equality of all its members, settling disputes in peaceful means, principle of good faith, prohibition of using force in international relations. Some of them are in quite accordance with principles of law recognized by a civilized nation and customary law. Article 4 consists, so here are the principles, sorry. Article 4 consists requirements which a state has to fulfill to join UN. Basically, the country has to be peace-loving and accept the obligations contained in this charter. The following article states that country might be suspended from the exercise of the rights and privileges of membership by the General Assembly upon recommendation of Security Council, and the country also even can be expelled from UN, but this never happened. So we should maybe list the principles organs of UN. So we have General Assembly. I'm sorry. Yes, so we have General Assembly, Security Council, Economic and Social Council, Trustship Council, International Court of Justice, and Secretariat. First of all, the Trustship Council should not be in the center of our attention. The Trustship Council was established in order to supervise the trust territories. Created after the end of the Second World War, with the independence of Palau, the last remaining trust territory on October, in 1st October 1994, the council suspended operation. So starting from the General Assembly, General Assembly. General Assembly consists of all members of United Nations. The General Assembly is the main policy-making organ of the organization. It provides a unique forum for multilateral discussion. Each of the 193 member states of the United Nations has an equal vote. Scope of work of General Assembly is very broad. Articles 10 states that the General Assembly might discuss any question or any matter within the scope of the present charter or relating to the powers and function of any organs provided for in the present charter. General Assembly can discuss any matter related to peace and security, might also call attention of the Security Council to the situation which are likely to endanger international peace and security. General Assembly also is responsible for promoting international cooperation in the political, economical, social, cultural, educational, in the health field, of course, promotion of human rights. Also approving budget, reviewing annual reports from Security Council. General Assembly might also, what is very important, can issue recommendation to members of UN or to Security Council. What should be highlighted here is that the General Assembly is not a legislator in that sense, and its resolution are purely recommendatory. Such resolution, of course, might be binding if they reflect rules of customary international law or are related to formation of a new customary rule. But Assembly resolution in themselves cannot establish binding legal obligation for member states. The Assembly is essentially a debating chamber, a forum for the exchange of ideas and discussion of a wide-ranging category of problems. Voting in General Assembly, each member have one vote. Important questions are being decided by a 2/3 majority, and other decision with the majority. It is also listed in UN Charter what are those important questions, and important questions are recommendation with respect to maintenance international peace and security, the election of non-permanent members of the Security Council, the election of members of the Economic and Social Council, the admission of new members to the UN, the suspension of the rights and privileges of membership, the expulsion of members. Now we will discuss the Security Council. The primary responsibility of the Security Council is to maintain international peace and security. And its powers are concentrated in two particular categories: the peaceful settlement of disputes and the adoption of enforcement measures. We have 11 members and 5 permanent. China, France, Russia, UK, and USA are those permanent members. General Assembly selects 6 other members of the council. Pakistan has been elected 7 times into the Security Council, with the most recent term in 2013. Each member have, sorry, let me just go to the next slide. Yes, each member have 1 representative and 1 vote. Decision on procedural matters shall be made by minimum 7 members. On all other matters, decisions shall be made by 7 members, including the concurring votes of the permanent members, which means that the permanent members have the veto. The veto was written into the charter otherwise, USSR, in particular, USSR would not have to been willing to accept the UN, and the veto was supposed to protect USSR from the Western bias and of the Council and the General Assembly at that time. The problem is that the question of how to distinguish between the procedural and non-procedural matters has been also highly controversial. What is a procedural matter? It's also subject of a veto. So this is so-called double veto is a formidable barrier for efficient work of Security Council. Because of the existence of the veto, this article is one of the most criticized article. Security Council's issue decision. The Article 25 states that the members of the United Nations agree to accept and carry out the decision of the Security Council in accordance with the present charter. The Security Council can also issue recommendations which are not binding, but it's not the same case with the Security Council as with the General Assembly. Security Council decisions are binding, and this is also very important. Now we have another extremely important article, Article 33, established the rule of pacific settlement of disputes. The Article 33 states that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice. Security Council might also start its own investigation if there is any situation which might be a threat for international peace and security. But also any other member or even not member of UN might bring this any kind of this situation or dispute into Security Council attention. Of course, Security Council will try to seek solution in peaceful means, issue recommendation, but if it's not enough, we have Article 41. Article 41 states that the Security Council might decide what measures not involving the use of armed force are to be employed to give effect to its decision, and it might call upon the members of the UN to apply such measures. This might include complete or partial interruption of economic relation and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of the diplomatic relation. But even if those Security Council actions are not enough, we have Article 42, which is one of the exemption of prohibition of using force in international relation. So we have actually two exemptions. The one, or we can say even three. The one is self-defense. The second would be the collective self-defense, and the third one is using force by Security Council. We have here Article 42, which states that should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it might take such action by air, sea, or land forces as might be necessary to maintain or restore international peace and security. Such action may include demonstration, blockade, and other operation by air, sea, or land forces of members of the UN. Those operations are established and implemented by United Nations itself, with troops serving under UN operational control. In these cases, peacekeepers remain members of their respective armed force and do not constitute an independent UN army. As the UN does not have such force, the UN peacekeeping mission are also called as Blue Helmet. And second exemption of prohibition of using force in international relations we can find in Article 51. As I mentioned, Article 51 is related to its Article 51 states that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the UN until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority of the and responsibility of the Security Council under the present charter, etc., etc. So basically, the whole topic of using force in international relation, it's quite complicated, and for sure it's not a topic for today. I think what is the most important right now is just to remember that there are those exemption of using of prohibition of using force in international relation. So we have chapter 8, which deals with the regional arrangement. It is basically allowed to create different regional arrangements as long as they are consistent with the purposes and principles of UN. Chapter 9 is about international economic and social cooperation. Chapter 10 regulate the Economic and Social Council. The Economic and Social Council has 8 members elected by General Assembly. The role of the Economic and Social Council is to conduct and initiate studies and reports in the field of economic, social, cultural, educational, health related matters, recommendation to General Assembly and issuing recommendation to General Assembly and members. What is very important that the Economic and Social Council prepare draft convention for submission to General Assembly, call international conferences, entering into agreement with specialized agencies, and reviewing reports from specialized agencies. The specialized agencies are, for example, UNESCO, International Labour Organization, Food and Agriculture Organization, International Criminal Court, International Organization of Migration, International Seabed Authority, International Tribunal for the Law of the Sea, World Bank or WHO. We have also Secretariat. The Secretariat is the United Nations executive arm. The Secretary General, who is appointed by General Assembly, is the head of the Secretariat. The role of the Secretary General is as an important peace-making actor has evolved through extensive practice. The range of activities carried out by Secretary General has included good offices, mediation, facilitation, dialogue process, and even arbitration. I remember that when I was passing public international law exam, quite often was the very popular question was what are the good offices? The good offices is a technique of peaceful settlement of an international dispute in which a third party acting with the consent of the disputing state serves as a friendly intermediary in an effort to persuade them to negotiate between themselves without necessarily offering the disputing state substantive suggestion towards achieving a settlement. Next article, which I think is just to finish the UN Charter, is Article 103, which again is very important. It's related to hierarchy of sources of international law. We have primary, secondary sources, we have different treaties, and what is the hierarchy? This is a very complicated matter again, and we could discuss this for hours, but what is important right now to remember that we have Article 103, which states that that in the event of a conflict between the obligation of the members of the UN under the present charter and their obligation under any other international agreement, their obligation under the present charter shall prevail. So I think that that's it about UN Charter. We will now go quickly through the International Court of Justice Statute. So International Court of Justice is based in The Hague. In International Court of Justice is a principal judicial organ of UN. What is very important to mention that only states might be parties in cases before the court. This is very important to mention because I have noticed that there are many confusion with all those international courts and tribunals amongst the students. We have, for example, International Criminal Court, which is also based in The Hague. We have Permanent Court of Arbitration, which is based even in the same building as International Court of Justice. We had a tribunal for former Yugoslavia, also in The Hague, for Lebanon, right next to The Hague in Late Haydam. Later on, we have, for example, in European Court of Human Rights, which is again being quite often confused as a part, for example, of EU system. It was set up, but the International Court of Human Rights was set up by the Council of Europe. And we have also Court of Justice, which is working in the framework of EU. So now, for example, we have the GAT case in the International Court of Justice. So I think most of us here in Pakistan know that International Court of Justice has nothing to do with individuals, that it's between India and Pakistan. Of course, it is related to the individual. In this case, it's an Indian national, but he is not a party in this case. India filed an application claiming that Pakistan violated Vienna Convention on Consular Relations from 1963. Of course, first, when we think about International Court of Justice statute, the most important, or maybe best, most well-known article seems to be Article 38, which describes the sources of international law. We will not deeply analyze the sources. I will just say 2-3 sentences about this, because again, this is a topic, I guess, for a separate discussion. So in Article 38, we can read that the court, whose function is to decide in accordance with international law, such disputes are as are submitted to it, shall apply international convention, whether general or particular, establishing rules expressly recognized by the contesting states. So treaties are known by a variety of different names, ranging from convention, international agreements, pacts, general acts, charters, statutes, and covenants. We have also lawmaking treaties or treaty contracts, which are between two or small number of states. The second source of law is international custom as evidence of a general practice accepted as law. So the custom involves two fundamental elements, usus and opinio juris. Usus is the actual practice of states, and acceptance, and opinio juris is that acceptance by states of that practice as a law, that the countries are on the opinion that this is the existing law. We have also the general principles of law recognized by civilized nations. So these are these three are the primary sources of international law: treaties, custom, and the general principles of law recognized by civilized nation. With the general principles, I think it's quite difficult to understand what are those, but I think the easiest to explain would be that they are the cardinal principles of the legal system in the light of which international law is to be interpreted and applied. The general principles are core of legal ideas which are common to all civilized legal systems. We have also secondary sources of international law. In Article 38, it's written that subject to the provision of Article 59, Article 59 states that decision of the court have no binding force except as between the parties and in respect of the case under consideration. Subject to the provision of this article, judicial decision and the teaching of the most highly qualified publicists of the various nations might serve as a subsidiary for the rule of law. So it is important to mention that in international law there is no doctrine of precedent, which is known in common law systems. We have also point 2 of the Article 38, which states that this provision shall not produce the power of the court to decide a case ex equo et bono, which is the case, the decided case on the principle of justice and equity, if the parties agree thereto, and there is it's a quite common practice that actually International Court of Justice decide the cases on this principle. Decision of the court are binding on state members if any party to a case fails to perform the obligation. The other party may have recourse to the Security Council, which may, if it deems necessary, make recommendation or decide upon measures to be taken to give effect to the judgment. Judges are elected regardless of their nationality. Of course, they need to fulfill the basic requirements of as high moral character, qualification, competence in international law. We have 15 members selected regardless their nationality, but at the same time, we cannot have 2 judges from the same country. They are elected for 9 years with the possibility of re-election. No member can provide the impartiality of the judges. No member can exercise any political or administrative function or engage in any other occupation of a professional nature. No member of the court might act as an agent, consul, or advocate in any case. No member can participate in the decision of any case in which he has previously taken part as an agent, consul, or advocate for one of the parties, or as a member of national or international court, commission of inquiry, or any other capacity. No member also can be dismissed unless it is unanimous opinion of the other member that he has not fulfilled the condition which I just mentioned. Of course, judges also enjoy the diplomatic privileges and immunities when engaged in the business of the court. The general rule is that General Assembly and Security Council elect members from the list of persons nominated by national groups in the Permanent Court of Arbitration. The Secretary General preparing the list of the nominated person and submitting it to General Assembly and Security Council. Candidates must absolute majority of votes in both Assembly and the Council. Yes, all questions shall be decided by a majority of the judges present. Let me. Yes. All questions shall be decided by a majority of the judges present if the judgment does not have represent in whole or in part the unanimous opinion of the judges. Any judge shall be entitled to deliver a separate opinion. The judgment is final and without appeal. There is a possible revision. In the event of dispute as to the meaning of the scope of judgment, the court shall construe it upon request to any party. Yes, the organization of court is that the court select president, vice president, registered, which are elected for 3 years. And now, what is the jurisdiction of the court? This is also very important information. The jurisdiction of the court is founded upon the consent of the parties. The consent has to be voluntary. Court cannot therefore decide upon legal rights or third states, which are not the parties to the proceeding. As in the case of arbitration, parties may refer a particular dispute to International Court of Justice by means of a special agreement or compromise, which will specify the terms of the dispute and the framework within which the court is to operate. Apart from those instances where state specifically refer to a dispute, the court might also be granted jurisdiction over disputes arising from international treaties, where such treaties contain a compromissory clause, which providing for this. Quite large number of international treaties, both bilateral and multilateral, include this kind of clause, which awarding International Court of Justice jurisdiction with respect to questions that might arise from the interpretation and application of the agreements. So, for example, we have this kind of clause include the 1948 Genocide Convention, 1965 Convention on Investment Disputes, 1965 International Convention on the Elimination of All Forms of Racial Discrimination. The states parties to the present statute might also at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation, the jurisdiction of the court in all legal disputes concerning the interpretation of the treaty, any question of international law, the existence of any fact which is established would constitute a breach of international obligation, the nature of extent of the reparation made to be made for the breach of international obligation. So this was the third way how the country can become a party in the case in International Court of Justice. So it's the optional clause declaration. So special agreement, compromissory clause, and optional clause of declaration. I think I would only add that court can also issue an advisory opinion to the UN or a specialized agency. A UN or any specialized agency can request court to issue an advisory opinion, as stated in Article 96 of UN Charter. Yes, I think I don't have here this Article 96 here. The General Assembly or the Security Council might request the International Court of Justice to give an advisory opinion on any legal question. Other organs of the UN and specialized agencies, which might at any time be so authorized by the General Assembly, might also request the advisory opinion from the court. So I think that's it. I think I discussed the most important article of UN and International Court of Justice Statute. Thank you.
Thank you very much, Professor Beata Pollack. And now I will give you a brief on jurisprudence, and that will be followed by a session on criminal law by Advocate Mohsin Mumtaz. All right, so jurisprudence. First of all, why study jurisprudence? There are several valid reasons why one should study jurisprudence. And here I want to quote from the original publication of Allama Muhammad Iqbal's The Reconstruction of Religious Thought in Islam, where he says the teaching of the Quran that life is a process and progressive creation necessitates that each generation guided but unhampered by the work of its predecessors should be determined to solve its own problems. So jurisprudence provides us guidance without hampering us to resolve legal problems of our age. And here I want to quote another great scholar, Justice Oliver Wendell Holmes, who has stated that no one will ever have a truly philosophic mastery over the law who does not habitually consider the forces outside of the law which have made it what it is. And I must say the forces within the law also are very important to be taken into consideration. And it's the jurisprudence that help us understand those forces within and outside the legal system. Now, under Islamic law, jurisprudence is called usulul fiqh, and it's a combination of two words, asl, which technically means root, and in legal parlance, it means principle, and fiqh, which is literally understanding, and in legal parlance, fiqh is the hikmah or the wisdom, which is the knowledge of ahkam, which is the legal injunctions, with halal distinguished from haram. So halal is permissible and haram is prohibited. Islamic jurisprudence could be understood or could be, the knowledge of Islamic jurisprudence could be gained from various books. HEC has recommended Professor Niazi's book, Outline of Islamic Jurisprudence. Previously, Muhammadan Jurisprudence of Sir Abdurrahim was also recommended. And we also recommend Muhammad Hashim Kamali's book, Principles of Islamic Jurisprudence. For jurisprudence, there are several texts. In fact, you could have a full library of books just on jurisprudence. But HEC has chose to recommend a book published by John William Salmon, which was published in 1902, and its 12th edition was published in 1960s. And we recommend HEC, please reconsider your recommendation. If you are the one sitting on the board and deciding, and you are the one who studied jurisprudence, sir, your time has ended, life has moved on. After 16, Hart has published his influential books, and after Hart, so many other scholars have published lots of important books. Salmon's jurisprudence has become a historical text that was important in one point in time, but it is no more important in this point in time. It's more than 120 years old, and there is no reason why our students should read this archaic text. So the gods at HEC and at a Pakistan Bar Council, please reconsider your decision. We recommend for our students that they should have a look at Introduction of Jurisprudence, that is Loyal's, its basic texts and materials. It will provide you state-of-the-art developments about jurisprudence. Now, what I'm going to do is to provide you a structure of Salmon's jurisprudence that was followed. So, Sir John Salmon, who was a jurist from New Zealand, divides his book into two parts. First part is about legal theory, history, and introduction to sources and institutions of law. Very descriptive. Second is also very descriptive. It is about legal concepts such as capacity, legal rights, obligations, ownership, title, and possession. And the third is about specific laws such as law of property, obligations, procedure, evidence, and law of nations, that is public international law. Under no circumstances, this book is of less value, but remember, whatever thoughts, whatever concepts have been given, they are old. Lots of debates have moved on. I just want to give you an example of John Salmon, where he describes duties correspond to rights. So wherever there is right, there is corresponding duty. But Professor Hoffeld developed this notion where there is a complex typology. So we have strict rights, we have immunities, we have privileges, and then we have a fourth category also. And then as against these categories, there are also corresponding taxonomy, which is as against strict rights, we have duties. As against immunities, we have no rights. As against immunities, as against liberties, we have liabilities. And against powers, we have disabilities. So we would highly recommend our students to basically update their knowledge, but for the sake of passing HEC law graduate assessment test, you have to confine yourself to this archaic text, that's Salmon's jurisprudence of Salmon's jurisprudence. Now, if you want to conceptualize jurisprudence generally, the main debates could be understood in the context or as an answer to this one question: what is law? For Austin, it's commands of sovereign backed by sanctions. For Hart, it's combination of primary and secondary rules. For natural law scholars, it's natural laws, natural reasoning. What the state institutions or court apply as such is the law to realist school. And for Marxist critique of law, it's a method of control and governance, maybe suppression or order in society. So elites basically impose law in order to control the society. There are two main types of jurisprudence, or the theories in jurisprudence. We can divide them into under two categories. One are normative jurisprudence, what the law should be or must be, natural law. So law must be what the nature requires us, what gods or some superpower, extra supreme, extra human power requires us. Natural law is natural reason. As against this, utilitarian Bentham and his students argued that the function of the law must be greatest good for the greatest number of people. So law has utility in order to ensure that we live a happy life. Libertarians are not very happy about states interference in individuals' lives. They want the authority of the state to be as limited, as confined as possible. Then there are theories of justice, such as Rawls' theory. So we have this veil of ignorance, and then everyone decides about and makes such a rule as if those rules will apply to them. Economic and social analysis of law take into account the economic and sociological theories, such as utilitarian theory, whether there should be Kaldor-Hicks utility, where the size of the pie is increased and then shared, or it must be Kaldor-Hicks efficiency. Sociological analysis takes into account sociological and anthropological theories in order to enrich our understanding of what law is. As against this, there is a second type of theories, what we call disruptive or critical jurisprudence. It tells us what the law is. So the argument is that whatever people who belong to the previous set of theories try to tell us the law, it only tells us how the law should be. But the actual working of the law is much more complex. And it is much more nefarious or negative in its origins and design. For instance, for Marxists, law is just a tool by elites to control other people. Critical legal study says that, look, in taking inspiration from Marxist studies, that look, these judges tell us that they are basically ensuring rule of law, but their own personal interests are very much embedded into the way they decide. Realist school also tells us how the law really affects people's life. And very important stream of thinking is a feminist jurisprudence, which tells us that how patriarchy is embedded into our institutional and legal structures, how these were the male who basically interpreted, developed, applied these rules, and most of these rules are anti-women. And race theory tells us that how race is actually embedded into the superstructure of law that is applied. Postmodernists basically challenge the assumptions into the law about its independence, about its neutrality, about its fairness. And intersectionality scholars invite us that we need to look into multiple lenses. These are lenses of feminist theory, race theory, and postmodern coloniality in order to understand a phenomena. So this is what we call disruptive or critical jurisprudence, and it tries to understand the law how it is. And from is, then we can move on to how law should be. So I wish you success for your law GAT, which you, if you have studied law properly, must not be afraid of. I think it's not a very tough test, but most of you will pass it. It requires lots of effort to fail this exam. All right, so now we move on to Advocate Mohsin, if he's with us. But if he's not with us, then yes, he's very much with us. So Advocate Mohsin Mumtaz will introduce us to criminal law part in law GAT. Thank you very much for joining us, sir.
Thank you very much. So welcome again. The criminal law part I'll be discussing today is comprised of the Pakistan Penal Code. I'll be quickly referring to the provisions which are, there are actually 5 chapters of Pakistan Penal Code which we are looking at regarding our discussion. Today's topic, that is the law GAT preparation. That is chapter 2, general explanations and definitions. Chapter 4, general exceptions. Chapter 16, Offenses against human body, Chapter 16A, Wrongful Restraint, and Chapter 17, Offenses against human body. Let me just give a quick overview of the criminal law in general, and then let's just quickly turn our attention to the specific provisions which we will run through in the process. I'm sharing my screen to share a very short presentation, and then we will just turn to the relevant provisions. So a brief concept of criminal law. The Constitution makes it under the chapter of distribution of legislative powers. It clarifies that the criminal law of the land is within the legislative competence of Parliament. And of course, in this connection, we have adopted the Code of Criminal Procedure 1898 and Pakistan Penal Code 1860. Both legislations are colonial legislations, and we have as such adopted both with quite a few amendments which are minor in nature. So in terms of criminal law, we have a colonial system indeed. This is unfortunate, but it is true. India has moved forward and it has promulgated its own version of Code of Criminal Procedure in 1963, which is in vogue and which is being administered. So relationship between PPC and Code of Criminal Procedure, I'll be commenting in a summary manner in it. The Code of Criminal Procedure is a procedural law, of course, and PPC is a substantive law. The Penal Code prescribes, ordains, and lays down the acts, the substantive acts, which are called offenses. Any action taken against the penal law of the land is an offense. So PPC is the general law. Let me just clarify, it's the general law. There are other laws, special laws, which prescribe and which penalize specific actions as offenses, but PPC is the general law. How these offenses are to be prosecuted, how these offenses are to be presented before courts of law for adjudication is provided in the Code of Criminal Procedure. So, to this statutory law, the PPC and the Criminal Procedure Code, the courts have added to it by means of the doctrine of precedent. The doctrine of precedent is, of course, a doctrine which provides certainty, predictability, and evolution of the law. It's called the judge-made law. This is the short process of criminal justice system in Pakistan. It basically starts from police, then a case after investigation comes to the prosecution department, which has been recently evolved to oversee the processes of prosecution, the police, not exactly the police, but the investigation reports which are going to be tried by the courts. Then there are courts, and after conviction and sentence, there are prisons and correction systems. Here is general overview of what we are going to do today. General exceptions: criminal liability, private defense, offenses against person, and offenses against property. I'll just switch to the actual text of PPC so that we can take up the main part of our session. So, Chapter 2, General Explanations. This chapter contains the definition part of PPC, which is normally in legislative documents, you will find a section called definitions. But in PPC, they have scattered the definitions part and have incorporated the definitions in this chapter, which spreads from section 6 to section 52A of PPC. So we will just skim through. Section 8 prescribes that the pronoun he will include male or female numbers. Section 9 says singular includes plural, plural includes singular. Man refers to a human male being of any age. Woman denotes a female human being of any age. Person includes a company or association, whether incorporated or not. Public includes any class of public, servants of the state, government, judge, court of justice, public servant. Public servant is one of the most important definitions in PPC, which is referred by lots of other statutes, because this definition of public servant is well thought upon and is comprehensive. So according to this definition, commissioned officers in armed forces, every judge, every officer of the court of justice, every juryman, every arbitrator, every person who holds any office by virtue of his empowered to place or keep person under confinement, so on, so forth. So there is a detailed list which provides for the definition of public servant. Movable property, according to section 22, is corporeal property of every description. So everything which is permanently attached to earth is immovable, and the land itself, and every other thing is movable property. Wrongful gain, wrongful loss, gaining wrongfully, losing wrongfully are used frequently in the text of PPC. So wrongful gain is gain by unlawful means of property which the person gaining is not legally entitled. Wrongful loss, on the other hand, is loss by unlawful means of property to which the person losing it is legally entitled. Same are the definitions. Dishonestly means with the intention of causing wrongful gain to one person and wrongful loss to another person. Fraudulently means intent to defraud. Then these definitions continue, and year, month even are defined in PPC. Section 49 says word year or the word month is used. It is to be understood that the year or the month is to be reckoned according to the British calendar. So now we turn to chapter 4. Chapter 4 is general exceptions, and it spreads over sections 76 to section 106. Let me just comment on this chapter before we start going through the provisions. General exceptions are those acts which are not offenses, if done by a person under the circumstances which are mentioned in this chapter. The burden to prove these general exceptions if raised by the accused is upon the accused. However, the superior courts have ruled that this burden is not equivalent to the burden which is posed on the prosecution, that is beyond any reasonable doubt. So the burden on the accused to prove these general exception is of lesser degree, and the courts have ruled that if it creates a dent in the prosecution case, the burden will be seen to have discharged. So section 76 says that a person bound or by mistake Any act done by a person who is bound or by a mistake of fact believing himself bound by law is not an offense. The section is self-explanatory. Act of a judge when acting judicially, no act of a judge when acting judicially is an offense. Similarly, any action done by any person in pursuance of a judgment or order of the court is not an offense. Section 79 says a person who commits an act believing himself, which is number one, justified by law, number two, by reason of mistake of fact, has been done in good faith, or believes himself to be justified by the law in doing it, is not an offense. Accident in doing a lawful act is not an offense. Act likely to cause harm but done without criminal intent to prevent other harm is not an offense. Similarly, act of a child under 7 years of age is not an offense. Act of a child above 7 and under 12 of immature understanding is not an offense. So if a child of 6 years commits murder of a man by firing a gun with which he was playing, this is not an offense. However, when the same offense is done by a child of 11 years of age, it will be seen whether that child had that understanding or what was the nature and consequences of his conduct. Unsound mind, being of unsound mind is another exception. However, the insanity has to be adjudicated upon in accordance with the law relating to mental health. Act of a person incapable of judgment by reason of intoxication against his will is again not an offense. Similar are the other sections which are here. The important part in this chapter is the right of private defense, which starts from 96 and goes to 106. Section 96 says that nothing is an offense which is done in the exercise of right of private defense. So this principle embodies the age-old principles of right of private defense. Right of private defense extends to both body and property. However, right of private defense has its limitations. Section 99, the right of private defense in no case extends to the inflicting of the more harm than it is necessary to inflict for the purposes of defense. This is the general principle which governs the exercise of right of private defense. So if a person is throwing bricks at you and you have shot him with an automatic or other firearm and you have killed him, it will be said that you have exceeded your right of private defense and you will be liable for that act. However, if a person is throwing bricks at you and in response you have also thrown a brick on him which has hit him on his leg and consequently has injured him, or has hit him on his head and consequently he died from that injury, it will be seen that you just threw a brick upon him and you didn't intend to kill him, but your intention was to avert the danger posed by him, then your act will be covered under the right of private defense. There are 6 circumstances given by Section 100 when you are justified in causing death in exercise of your right of private defense. Number 1 is that the action and assault was reasonable enough to cause apprehension of death in your mind. Secondly, grievous hurt. Thirdly, intention of committing rape. Fourthly, gratifying unnatural lust. Fifthly, kidnapping. Or sixthly, intention of wrongfully confining a person with an apprehension that the person will not be able to have recourse to legal authorities. Similarly, other limitations are also defined by the other sections. Let us just quickly turn ourselves to chapter 16, which is of offenses affecting the human body. Section 200 gives the definitions. Important definitions there are. We will look at these definitions during our discussion. Section 300 defines Qatl-e-Amd. Qatl-e-Amd means whoever by the intention of causing death or with intention causing bodily injury to a person does an act which is in ordinary course of nature is likely to cause death, or with the knowledge that his act is so imminently dangerous that it must in all probability cause death, causes the death of such person is called Qatl-e-Amd. So in simple terms, Qatl-e-Amd is intentional action which results in murder of a person, causing death of a person. Causing death of a person other than whose death was intended. Section 301. If a person commits Qatl-e-Amd of another person in transaction of trying to commit Qatl-e-Amd of some other person, he shall be liable for Qatl-e-Amd. Punishment 302A is Qisas, 302B is Tazir, 302C is imprisonment for life. These three subsections have whole jurisprudence behind them, and there are a number of judgments explaining their scope. The next kind of qatl is qatl committed under ikrah-e-tam or ikrah-e-naqis. Ikrah-e-tam is punishable with a term for 25 years, while ikrah-e-naqis shall be punishable with the imprisonment which may extend to 10 years. Proof of Qatl-e-Amd liable to Qisas. What are the standards of proof if one needs to enforce Qisas as a punishment for Qatl-e-Amd? There are two propositions. Number one, a judicial confession by the accused or evidence as provided in Article 17, which is the evidence of adult male witnesses who have not committed, who fulfill the requirements of Tazkiyatu Shuhud. So Wali, 305 defines Wali, which means heirs of the victim. 306 defines when the offender is a minor, or the offender causes death of his child, grandchild, etc. Or Wali is the direct descendant of the victim. The Qisas shall not be enforced, which means if a man kills his father or father kills his son, Qisas cannot be enforced. Cases in which Qisas shall not be enforced, there are three cases. If the offender dies, if the Wali voluntary and without duress waives the right of Qisas, or the right of Qisas devolves upon the offender. So you see, Qisas is tooth for tooth, eye for an eye. Qisas is like committing murder of the person who has committed the murder of another person in the same way, with the same intensity and with the same act. So the requirements are higher. Punishments in Qisas not liable to punishments in Qatl-e-Amd, not liable to Qisas are provided by section 308. I'll have to just quickly skim through these because we have a lot to cover. Compounding of Qisas in Qatl-e-Amd. Section 310. I think I'm having a slight issue here. I'll just be sharing my screen again. In just a moment. Yes, we are back. So, compounding of Qisas in Qatl-e-Amd. Wali can compound. An adult sane wali may at any time on accepting badala sulh compound his right of Qisas. Where a wali is minor, the wali of such minor may compound. So basically at the heart of this concept, wali is the Muslim law of inheritance, which prescribes who will be the legal heir of a deceased. So every provision from that inheritance law is applied, and simply it is determined who is the wali. Then there are these offenses which have been made part of this chapter to avoid and to avert the custom of wani, giving a female into marriage in as a badal sulu. Then there are procedures, and then there is qatl shabih, another important kind of qatl. Whoever with intent to cause harm to the body or mind of any person causes death of that person. So the intention was of committing harm to a person, not death. And with an action which was not likely to cause death. So if a person strikes another person with a stone or a stick, which in ordinary course of nature is not likely to cause death, it will be called qatl shabih ahmad. The punishment is 25 years as tazir. Qatl khata is causing qatl by any act which is not in ordinary course of life and which is committed by mistake of fact or mistake of fact is the reason of causing the death of another person is called qatl khata. So the punishment for qatl khata is diyat. Diyat is 3,333 grams of silver, present value. Punishment of qatl khata was rash and negligent driving, which is apparent. Qatl bisabab is without any intention of causing death or harm, does any unlawful act. The act should be unlawful, and that act causes the death of another person. It is known as qatl bisabab. Value of diyat, as I have already stated, 30,630 grams of silver. Sorry, I think I'm just corrected. So 30,630 grams of silver. Attempt to qatl ahmad is also an offense. Now, there are these 5 kinds of hurts: itlaf-e uz, itlaf-e salayat-e uz, shaja, jur, and all other kinds. Itlaf-e uz is amputation of an organ. Itlaf-e salayat-e uz is doing an act by which an organ is disabled. Shaja, now comes 337, which is shaja. Shaja is of again 6 kinds. Let me just here remind you that this chapter was added in PPC and was It replaced the old law of murder and hurt, which is still existing in Indian Penal Code of 1860. And Qisas Diyat Ordinance was promulgated when the Federal Shariat Court in the late 80s and early 90s had ruled that the existing law of murder and grievous hurt was against the injunctions of Islam. So in order to bridge that gap, Qisas Diyat Ordinance was promulgated and these chapters were inserted in PPC. Shuja, Khafifa, Modiha, Hashima, Munakila, Amma, and Damega. You see, the Shaja offenses are upper body trunk offenses, which is the head or face of any person. So, Khafifa is without exposing bone, Modiha is by exposing bone, Hashima is by fracturing it, Munakila is by fracturing and dislocating the bone, Amma is by fracturing the skull, and Damega is by fracturing the skull and rupturing the membrane of the brain. So highest is Damega and lowest is Khafifa. So accordingly, the punishments have been prescribed. Jur, on the other hand, 337B, is the offense which, other than on head or face and hurt, leaves a mark on the wound. So other than face and head is Jur, Jafia, and Ghair Jaifa. So body cavity is included in Jaifa, and other than body cavity is included in Ghair Jaifa. Again, there are 6 categories of these offenses, which relate to, again, the same sequence: rupturing the skin, bone, fracturing the bone without dislocation, fracturing it with dislocation, and so on and so forth. And the punishments are also prescribed accordingly. Wali in case of hurt is the same, and Arsh, there is then this type of punishment, which is a percentage of diyat, which is called Arsh. So for teeth, there is Arsh, for hair, there is Arsh, and there are principles of merger of Arsh, and then Daman is also prescribed. Now, turning to chapter 16A, wrongful restraint. Whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. So there is nothing complicated in it. Wrongful confinement, on the other hand, is restraint on a person as to prevent that person from proceeding beyond certain circumscribing limits. So if you hinder a person in going in one direction, like in a road, and you prevent that person from crossing a certain point of that road, that is called wrongful restraint. And if you confine that person in a room, that will be called wrongful confinement. Then the gravity of these offenses increases as the action is aggravated by added illegalities and offenses. Then comes criminal force and assault. Criminal force and assault include using force against a person, against that person's consent, and in that manner is committed an offense. So this comes within the definition of criminal force. And by any gesture or preparation which intends to cause a criminal force to be used against a person, that is called assault. Now, quickly coming to abduction, kidnapping, and slavery. Kidnapping is of 2 kinds: kidnapping from Pakistan and kidnapping from lawful guardianship. Removing a person from the limits of Pakistan without consent is kidnapping, and kidnapping from guardianship is kidnapping of a person under 14 years of age. If male, under 16 years of age, if female. And abduction means other than, so persons of males of above 14 years and females of above 16 years are covered under abduction, and then punishments for those offenses are also provided. 365B is a notable offense because it entails higher punishments, and it involves kidnapping, abducting, or inducing women to compel for marriage. And another offense which has been recently added is 365A, kidnapping or abducting for extorting property and valuable security. This was inserted to prevent the increasing number of ransom crimes. So the chapter goes on, and let us just concentrate on chapter number 17. Offenses against property. Section 378 of PPC prescribes the offense of theft. Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Now, the ingredients of most essential ingredients of theft are dishonestly, intention, movable property, and out of possession of a person without that person's consent. All these are ingredients of theft, which when fulfilled make an offense to be an act to be an offense. Punishment for theft has been provided as 3 years. Theft in dwelling house. Now the offense of theft is now aggravated by adding various situations. If the theft is committed in dwelling house, the punishment is up to 7 years. If the theft is committed by a clerk or servant, the punishment is again to 7 years. If theft is committed in relation to a motor vehicle, the punishment is 7 years. And then theft after causing death, preparation made for causing death, hurt, or restraint in order to committing of the theft, punishment is rigorous imprisonment for a term which may extend to 10 years. Extortion means putting any person in fear of any injury to that person or any other or to any other person, thereby dishonestly inducing that person to deliver any property or valuable security. So the offense of extortion is punishable with 3 years. Then again, the offense of theft, offense of extortion is aggravated by surrounding circumstances. And in this relation, again, there is this part of this chapter which relates to robbery, section 390. Section 390 is robbery. Robbery is an aggravated form of theft. Theft is robbery if in order to committing of the theft or in carrying away or attempting to carry away property obtained by theft, offense for that and voluntary cause or attempts to cause any person death or hurt or wrongful cause. So if death or hurt is committed during theft, it becomes robbery within the meaning of section 390. And robbery by 5 persons, 5 or more persons is dacoity. So the difference between robbery and dacoity is the number of persons mainly. And the punishment for both the offenses are different. For robbery, it's not less than 3 years and not more than 10 years. And if committed on highway, it may be extended to 14 years. While in relation to dacoity, it's not less than 4 years and not more than 10 years. So then these offenses are again aggravated by various circumstances. Then comes hijacking. And hijacking is punishment with death, imprisonment for life, or forfeiture of property. Then comes the part criminal misappropriation of property. Whenever a person uses one's movable property, misappropriates it or converts it to his own use, it's called dishonored misappropriation of property. It has different kinds then. Criminal breach of trust is one of its kinds. Criminal breach of trust means that any person having any dominion over property dishonestly misappropriates or converts it to his own use, then it is called criminal breach of trust. Criminal breach of trust is punishable in section 406, which is with 7 years or with both. 7 years imprisonment or with both. Criminal breach of trust by carrier, by clerk of servant 408, you will come across it in many ways. The punishment for this is 7 years. Then receiving stolen property is also an offense, and then the chapter turns to cheating. So and other important sections in this chapter are 420, which is cheating and dishonestly inducing delivery of property. And then read with these section 420 is section 468 and section 471. Section 468 is forgery. I am just referring to 468 and 471 because often these are appended by the police in the FIRs. Forgery is making a false document with intent to cause damage or injury to the public or to any person. And 468 basically is forgery for the purposes of cheating. That's why it is used with for section 420. And 471 is using a forged document as genuine one. This entails a punishment. 471, 468, and 421 entails punishment because these are listed offenses. So this was the overview of the 5 chapters which are including in the syllabus. If there are any questions, I am available to those questions. Thank you very much. Over to you, Abasi-san.
Thank you very much, Advocate Mohsin Mumtaz. And now we move on to law of evidence, and we have with us Professor Dr. Shahbaz Ahmed Chima. Over to you, sir. Sir, please unmute yourself.
Is it okay now?
Yes.
Hear me?
Yes.
Yeah. I am supposed to talk about the portion relating to law of evidence today for the students who are preparing for law GAT. Let me first share the PowerPoint which I have prepared for this purpose. Just a minute. Hopefully you can view the PowerPoint now. Is it visible to you?
Yes, sir. Yes.
Okay. So there are 20 marks allocated to Kanun-e-Shahadat order, and the whole law of evidence, whole Kanun-e-Shahadat order is made part of the law GAT course. And it's not easy to comprehensively conclude the whole topic in 30 minutes. But what I will do during my presentation to give you the overall idea or present the summary of those basic concepts which most of you would be familiar otherwise. And that summary is basically in made in the slides which are running on your screens at the moment. So the first slide deals with the history of law of evidence, history of law of evidence. So the law of evidence which we have at the moment, which was enacted in 1984, it was basically drawn from the Indian law of evidence, which was enacted initially in 1872. And the author of the law of evidence was Sir James Stephen, who was law counselor appointed by the British Raj to carry on the enactment process here in Indian subcontinent. Law of evidence was, and when they drafted the law of evidence, the British Raj drafted and introduced the law of evidence. At that time, there was no comparable legislation in UK, United Kingdom, and the law was first time enacted by British and introduced that law in the Indian subcontinent. And this law was evidence was a comprehensive legislation, and it incorporated into it the basic principles of common law, because their own system was known because of precedent and customary practices. So what they did while drafting the law, they incorporated those principles which were already established in their jurisprudence, and those many provisions of the law of evidence, Indian law of evidence, reflected those basic principles. And when in 1984, a debate about Islamization of law was started, and it was pointed out that there were some provisions in Indian law of evidence which are not Islamic, and that debate led to the remodeling of Indian law of evidence, and know what we have at present, which is a replacement of Indian law of evidence, that is termed as Kanun-e-Shahadat order. And this Kanun-e-Shahadat order has incorporated majority of the provisions of the Indian law of evidence. If we try to give a percentage of this, we will notice that there are more than 95% provisions of Indian law of evidence which are still retained in Kanun-e-Shahadat order. And whenever I teach during my class, I encourage students to go and find good books on Indian law of evidence and study those books, because the interpretation given on those books relating to at least those provisions which are in our Kanun-e-Shahadat order, that interpretation is still followed by the Pakistani courts. But there are some provisions, as I have pointed out, which have been converted are replaced by the Islamic provisions, and these provisions are, let me give you the summary of those provisions. And these provisions, the 6-7 provisions are there, are provisions in which Islamic principles or rules have been incorporated, and these 6 provisions are in front of you on the screen. First provision deals with the competency of witnesses, competency and number of witnesses. Competency is the topic of the Article 3 in Kanun-e-Shahadat order, and that provision basically narrate the principle that all witnesses or all people are competent witnesses unless they are prevented just because of their understanding or immaturity, or they are unable to answer the questions in a rational manner. So that provision is still there, but it is added in that provision that those who commit perjury, those who commit cause, they are not allowed to be witness in the court. And this provision that preventing those who have committed perjury or cause, that provision is drawn from Surah Nur. So then coming to another provision, sorry, my light has switched off and there is no UPS connection in my room. Anyhow, let me move into another location so that
Sir, it's not an issue as long as we can hear
okay,
you.
okay,
Yes.
okay,
Yes.
okay, okay.
Yeah.
If it is not an issue, so
Yeah.
let me continue. So another provision in which Islamic provision principles have been incorporated, that deals with the number of witnesses. Number of witnesses, as far as the old law is concerned, there no minimum number of witnesses or no maximum number of witnesses was provided in that law. But in Article 17, which we have now in Qanun-e-Shahadat order, there are few instances in which number of witnesses are specifically required. For example, in cases of hudud, in cases of qasas, in cases of diyat, and then there are those civil transactions in which some type of property is transacted, or some type of future responsibility has to be committed. In those circumstances, number of witnesses are specifically prescribed. So you people must have those requirements in your mind, that in case of most of the hudud and qasas cases, 2 witnesses are required, 2 male adult Muslim adult witnesses are required. But in case of zina, there are 4 requirement of 4 witnesses is mandated. And in those civil transactions where property or future of financial transactions are uh, contracted between the parties, in those situations 1 male and 2 female witnesses or 2 male witnesses. And this is something which is drawn from verses of Surah Baqarah. So another thing which has been added into the concept of competency of witness, that pertains to the Tazkiyatu Shahood. All witnesses who appear before the court, they are generally presumed to be competent witnesses. They are presumed to be adil witnesses, all Muslim witnesses. This is how jurists have written in their books, and this is how our courts treat it. But in those cases where had and qasas penalty is implemented, in those circumstances, courts are legally bound to ascertain whether those witnesses are really competent to be treated as witness. And this caution is generally followed just because of the fact that the severe penalty is going to be inflicted upon them. That's why their competency as a witness must be beyond any doubt, and they should be competent witness. They should be adil witnesses. Not only competent, they should be adil witnesses. But as far as the punishment in tazir cases and normal civil litigation is concerned, there is no requirement of tazkiyat shahood, and whosoever appears before the court, he is considered to be a competent witness, and his evidence is treated fairly on the merit, whether it is true and not, whatever. And let's come to the another provision in which Islamic principle has been incorporated, that is that deals with the accomplice. Accomplice evidence is accomplice is considered to be a competent witness. And but in exceptional cases, his evidence is not given any credence, and those cases pertain to hudud and qasas. And the why accomplice evidence is considered worth considering in Tazir, and why this evidence is not considered as relevant in Hudud and Qasas. The distinction is basically on the fact that in in those circumstances where Islamic punishments are inflicted or applied, in maximum caution is applied to ascertain the competency of a witness in context of Islamic provisions, because accomplice is a self-proclaimed offender. He is the one who says that he has committed offense in collaboration with another person. So when he says something like this, he has self-confessed the crime. So a person who has confessed the crime, he is basically a fasik witness. And when he is fasik, his evidence must not be considered in hudud and qasas cases. So the accomplice is competent in tazir cases, but his evidence is not considered in hudud and qasas cases. And then another concept of shahada ala shahada, that is also drawn from Islamic law, and this concept is incorporated in Article 71 of the Qanun-e-Shahadat order. Generally, Islamic law, similar to the common law, requires that a witness must be present in the court to give his evidence. But here, in exceptional circumstances, Islamic law allows that a witness may depute two witnesses on his behalf, and a witness is unable to come before the court, and he may depute two witnesses on his behalf, and he can confine his evidence to those witnesses, and those witnesses may bring that evidence before the court. The requirement of two is mandated here just because of the fact that if there is one witness, he may add or subtract from that evidence, but when there are more than two witnesses, there is less possibility of adulterating the evidence they were supposed to bring before the court. And this concept is known as shahada ala shahada. And then another provision dealing with the legitimacy and paternity, that is provided in Article 128, that the concept of paternity and maternity and legitimacy, those who have done LLB, they are well aware of this concept. And in Islamic law, the presumption of legitimacy is one of the very sacred presumptions, and that's why if we go through and see the provision in Article 128, you will see there is a definite tilt toward presuming someone as legitimate. And whenever there is a marriage and the child is born after 6 months of marriage, he will be attributed to the couple until the dissolution of marriage. And even after the dissolution of marriage, this period will continue up to 2 years under certain circumstances specifically mentioned in Article 128. And then coming to the requirement of oath, we normally say that and read in literature dealing with Islamic law that oath is one of the modes of proof in Islam, and this concept has been incorporated in Article 26, and this concept is generally applied in petty matters and generally applied in civil nature of transactions where there is no witness available. But as far as the effectiveness of this method is concerned, a lot needs to be researched on this, because there are very few cases in which this matter is actually resorted to in our courts. So coming to another point, dealing with relevancy and admissibility, reliability, these are the foundational concept of law of evidence, Qanun-e-Shahadat order and Indian law of evidence. Whenever we say what kind of evidence is given in evidence law, let me go back to another slide which I skipped during the course of discussion, and because I have to connect this slide to that one, and that deals with the basic principles of law of evidence. And there are 3 basic principles on which the Indian law of evidence was founded, and these 3 principles are still intact in our law of evidence, Qanun-e-Shahadat order, and majority of the provisions in Kanun Shahadat order basically reflect the efficaciousness of those three principles. And which are those principles? Number one is evidence must be confined to matters in issue, and the concept of relevancy, admissibility, that is the basic reflection of this very principle. And then the second principle, hearsay evidence must not be admitted. Hearsay evidence was excluded in common law. Hearsay evidence is not treated with any favor in Islamic law as well. So this principle is also incorporated in a number of provisions, and there are many exceptions to this principle. I will later on point to those exceptions. So the third principle deals with the best evidence rule. So there are situations in which we may have many kinds of evidence. One piece of evidence is good, another is better, and another is best. So what law requires that the evidence which is best in any specific circumstances, that evidence should be presented. These are the basic three principles on which our law of evidence is based. And now coming to the relevancy, admissibility, and reliability, as we know that this is basically reflect the principle of evidence must be in matters related to the matters in issue, and how these matters in issue could be ascertained. Those matters in issue could be ascertained on the basis of relevancy of evidence. So there are number of provisions in law of evidence. If we try to enumerate them, they start from Article 18 and go till 69, and in those provisions we see that the number of facts are enumerated in each and every provision. There are provisions in which 5, 7, 6 kinds of evidence or pieces of evidence are specifically mentioned. So as far as these provisions are concerned, they are 51. But as far as the pieces of evidence are concerned, majority of evidence which we deal with in courts nowadays, that evidence is relevant on the basis of those provisions. These legal provisions are from Article 18 to 69. So the concept of relevancy is, as far as our legal system is concerned, our legal system assumes that there are two kinds of relevancy. One is a legal relevancy and another is logical relevancy. So, but our law has preferred the legal relevancy over logical relevancy. What do I mean by this? The meaning of this statement that legal relevancy is preferred over logical relevancy is that, so whatever is legally relevant, irrespective of the fact whether that is logically relevant, that piece of evidence could be presented in the court as evidence. But if something is logically relevant, but that is not legally relevant, that could not be presented as evidence. This is what relevancy is all about. So whatever is declared to be relevant in law of evidence, in any provision of law of evidence, irrespective of the fact whether we logically declare that piece as logically relevant or not, we have to accept that piece of evidence as relevant evidence because that is legally relevant. So the relevancy in Kanun Shahadat order is a legal concept. Why I am emphasizing on this particular point? Because in common law, this point is still a logical, they prefer logical relevancy over legal relevancy. In UK and elsewhere in Australia, their rules, they haven't exhaustively laid down the list of relevant pieces of evidence. So what they encourage to be presented before the court, that should be logically relevant. But in our legal system, the provisions are there, detailed provisions are, comprehensive provisions are there. And whenever somebody brings any piece of evidence before the court, he has to prove that legal relevancy of that piece of evidence. And another concept which is connected with relevancy, that is admissibility. And all those pieces of evidence which are relevant and they are allowed to be presented before the court, and court can deal with them, and there is no prohibitory clause in the law of evidence, those pieces of evidence are considered to be admissible pieces of evidence. Generally all admissible evidence is relevant evidence. So admissibility is presumes that it was legally relevant. So that's why that piece of evidence is allowed to be presented in the court. But sometimes relevant evidence is excluded, that even though that piece of evidence is relevant under any provision of law, but that piece is not allowed to be presented before the court. So the evidence is relevant, but that is not admissible. This concept, if we go and see the provisions from Article 4 to 15, which deals with different kinds of privileges and protections to various kinds of persons and various kinds of pieces of evidence, that concept is provided there. For example, judges um, may see something happening in front of them in the court, but they cannot be asked to be witness about that, which comes into their knowledge when they are functioning judicially. If someone is a police officer and he has a source of information, he is not legally bound to disclose that source of information. That source of information is relevant evidence, but that is not admissible evidence. Whatever kind of communication under Article 5, communication between spouses, um, even a spouse confesses before his better half, even then that piece of evidence, that confession is relevant if done in front of any person, but the confession before police and before a spouse is not relevant under Article 5. So the piece is relevant, but that is not treated as admissible. So the concept of admissibility is founded upon relevancy. And when we say that some piece of evidence it is admissible, it means it was originally relevant. But when we say that some piece of evidence is relevant, that doesn't mean that it must be admissible, because there are provisions which prevent admissibility, which might prevent the admissibility of that piece of evidence. So there is a tricky relationship between these two kinds of concepts. And then there is a third concept, which is also very foundational for understanding the law of evidence, that deals with the reliability of evidence. Law of evidence hasn't dealt with this concept and left it open to the judicial conscience. So whatever piece, whatever witness whose evidence is considered to be relevant, that hasn't been dealt anywhere in law of evidence. So when we read cases, or we hear about a court proceeding, what we see that advocates contest about relevancy of peace on the basis of legal provision. But when they come to the concept of reliability of pieces of evidence or reliability of witnesses, they don't connect it with the legal concept, because this concept of reliability is a common sense concept and it is applied on the basis of common sense. If a witness has spoken before court something, whether that something is relevant is a legal issue. But what he has said, whether that is truthful or not, this depends upon the factors which are not legal. Court has to evaluate those factors in terms of circumstances surrounding that very fact, the manner of adducing evidence, whether those facts are proved from other facts, whether this evidence is uh, possible factually that could happen. And these are the things which are matters to be considered in when dealing with the reliability. So the point which should be kept in mind, that the concept of reliability hasn't been dealt in law of evidence. In each and every circumstances, the court has to determine the reliability of piece of evidence and the reliability of witness. This has to be done by the court in each and every situation. So let's come to the as we narrated earlier, that there are three principles, and the first principle dealt with confining the evidence to the matters in issue, and we connected this concept with the relevancy and admissibility of evidence. And at that place we said that there are provisions in which articles are enumerated specifically, on which facts are relevant, and this is the extended list of those provisions. These are just illustrations. These are not. This is not a comprehensive list. And for res justice, relevant piece of evidence, circumstantial evidence in Article 19 and 20, motive preparation in Article 21, identity and relationship in Article 22, alibi Article 24, evidence pertaining to rights and customs 26, and there are some other provisions of it, and similar fact evidence Article 26 and 27, admission confession. There are provisions from Article 30 onward, 45 dealing with admission and confession, dying declaration Article 46, and some other kinds of statements mentioned in Article 46, and then relevancy of judgment, expert opinion from Article 59 to onward 65, and then character evidence 66, 7, 8, 9. These are the provisions in which pieces of evidence have been pinpointed, specified, which can be produced as relevant pieces of evidence in the court. And when we say they can be produced as relevant pieces of evidence, the next question, how much value these pieces should be attributed by the court that is not mentioned in the law of evidence, and that job has to be done by the court. Generally, we say that circumstantial evidence is not of much value, but there are cases in which death penalty is even implemented on the basis of circumstantial evidence. And then confession is a very valuable piece of evidence. Confession and admission are very valuable pieces of evidence, but we see cases in which despite the confession was made, but even then the accused was acquitted just because confession wasn't voluntary, or there were vitiating circumstances. So when we say that these pieces of evidence, we are not concluding that on the basis of these pieces of evidence, court must conclude whatever is suggested by these pieces of evidence. So the inference from the evidence has to be drawn by the court, and in drawing that inference, court has to consider other circumstances as well. And then all those pieces which are mentioned on this slide, we can talk about at length on them, but due to the constraint of time, we can't point out each and every piece. Let me just give you 2 or 3 examples. For example, the evidence of dying declaration. And dying declaration, this is basically a hearsay evidence. The one who has made declaration, he wasn't before the court. He was laying somewhere after being shot, and or after an accident, or whatever was the cause, and he narrated before his death what happened to him. So this piece of evidence, whoever heard that piece, he would come before the court and narrate that piece of evidence. So the question, what kind of value this piece of evidence should be given? Generally, we presume that those who are nearing their death, they speak truth. And just because, why we tell a lie? Just because of fear or any greed. So those who are going to meet their Lord, they are not going to tell a lie generally. So this is the assumption on the basis of which we see that dying declaration is given immense importance in courts, and on the basis of this very evidence, even in without corroboration or substantiating evidence, independent substantiating evidence, convictions are recorded. But there are cases in which court specifically requires that there should be some sort of independent evidence when the manner in which the dying declaration was recorded was suspicious, when the witness might have some relationship or motive to falsely implicate the accused person. So in those circumstances, even despite proving of the dying declaration, courts insist that this piece of evidence must be corroborated from independent evidence. Relevancy of judgments, basically, when we read this particular area of law of evidence, we generally confuse the concept of precedent and relevancy of judgment. Concept of precedent is based upon the constitutional provisions, and in Constitution, it is specifically mentioned in the chapter dealing with judicature that the decision of Supreme Court on the point of law are binding upon subordinate judiciary. And this is also mentioned in the chapter dealing with High Court, that the decision of High Court is also binding on point of law on all courts which are subordinate to that particular High Court. So the law of precedent is based upon the concept of legal point. Where there is the law point, law of precedent will be followed and judgment will be considered in constitutional context in the court. But where there is an issue to be determined by the court that pertain to the fact, in that particular situation, court has to require evidence of that particular fact. Factual proofs cannot be proved on the basis of any other judgment, any previous judgment. So this particular area of relevancy of judgments deal with those situations in which judgments can be produced before the court to prove some particular fact, not some particular law. Because as far as the law point is concerned, judgments of superior courts are binding on subordinate courts. But as far as the question of fact is concerned, court has to evaluate the evidence independently without being influenced by the decision of any other court, So the judgments on questions of fact are not generally relevant, and this is the general principle. And when we read those provisions, we will see that there are 3 or 4 exceptions to this general principle, and those provisions relate to questions of fact, not with question of law. Next point is with reference to the expert evidence. Expert evidence or expert opinion. Opinion must not be confused with fact. What court requires is evidence of a fact. Court doesn't require evidence of opinion, because the court has to form its own opinion on the basis of fact presented before the court. So in general, the opinion evidence must be excluded, must not be entertained. This is a general principle. So when we read the provisions dealing with expert opinion, those provisions are basically exception to this general principle. And the general principle is evidence must be presented relating to the facts, not relating to the opinion. Opinion forming is the job of the court, and no one can abdicate this job from the court. And when somebody appears before the court as an expert to give some opinion, his opinion must be with reference to those provisions which are there in law of evidence. So when we say that opinion evidence can only be presented as an exception, so that must be connected to specific provision of law. So expert evidence is allowed in those cases where the law has provided an avenue to entertain the expert, and because those are the cases in which the court may not reach to an appropriate conclusion without having information about without having assistance of any expert witness. That's why this is allowed exceptionally. And what is the value of expert evidence? That depends upon the expertise of the individual who is before the court. If he is well versed in his area, what he has demonstrated before the court, that is substantiated on the basis of scientific evidence. His evidence might be given value, and if he is before the court, but he is merely narrating generic principles and he hasn't assisted court in any specific manner, and whatever he has said that has not proved independently scientifically, so his evidence might not be given any value. And then the area in which the evidence is presented before the court, how far that area is technologically accomplished or refined. For example, DNA evidence is given more value than other kinds of evidence. Why? Because DNA, the science of DNA has accomplished a much, and the margin of error has been reduced to nullity. That's why DNA evidence is given much more value as compared to the evidence of any other medical professional who is before the court and gives about the evidence of injuries and cause of death and something like this. Now coming to the exclusion of hearsay. Second principle was relating to the exclusion of hearsay evidence. Why hearsay evidence is excluded? There are some generic explanation to this in this context. One is hearsay evidence was not before the court, so it was without oath, and the opposite party didn't have any opportunity to cross-examine, and then there was possibility of perjury or mixing up that evidence. And when somebody has narrated a false evidence before the court after hearing it from somebody else who is not before the court, he might add into it or he might subtract that evidence. So these are the possibilities on the basis of which court generally insists that the evidence of the person who has witnessed any incident or any transaction, he must come before the court to produce as evidence. So then this is, that's why we see there are provisions in law of evidence which insist on production of direct evidence. Oral evidence must be direct in Article 71, and then the definition of fact as provided in Kanun-e-Shahadat order, that who has sensed any fact on the basis of his five senses, he should come before the court and give that evidence. So when we read these two provisions, Article 71, along with the definition of fact, we will reach to the conclusion that whoever witnessed, whoever heard, whoever sensed anything, he must come before the court to give evidence of the fact he has perceived. And no one should represent him in the court. So this is the direct kind of evidence. So oral evidence must be direct generally, but there are exceptions, and one of the exceptions we have already mentioned of shahada ala shahada when we were dealing the concept of Islamic provisions in Kanun-e-Shahadat order. And then there is res justae, the evidence presented under Article 19, that might be direct or that might also be indirect evidence. So hearsay evidence, indirect evidence could be entertained under Article 19. That's why it is as mentioned as an exception to hearsay rule. Then admission and confession. When admission and confession is made before the court, that is the judicial admission or judicial confession, that is direct evidence. But when admission or confession is made out of the court, so then that is not direct evidence, that is indirect evidence. So this could also be considered as an hearsay evidence. Dying declaration and other kinds of statement mentioned in Article 46, they are illustrations of hearsay, exceptions to hearsay evidence. Then Article 47 dealing with the statement made before another court, as we have said little bit earlier, that court generally require a witness to come before them and state his evidence before the court, but if something was stated by a witness in another court, and whatever statement that was made in another court, that statement must not be brought before the court because it would become an indirect evidence. But in exceptional circumstances, this is allowed, and those circumstances are mentioned in Article 47. For example, witness is dead, he is not available, he is not in a position to give evidence, and whatever he has said that was relevant, and the party against whom his evidence is going to be used, he had the opportunity to cross-examine him in the previous proceedings. So these are the requirement. If these requirements are met, then his evidence could be entertained. Some more kinds of exceptions are mentioned in Article 48 to Article 51, statements which are written in a register and written in official records. These kind of statements are basically presented and treated as evidence in itself, though they are indirect evidence of the fact narrated therein. The last principle dealing with the on the basis of which the law of evidence is based is the best evidence rule, as we have mentioned it earlier, that in one particular case we may have many kinds of evidence. Some pieces of evidence are good, some are better, some are best, and law insists or requires that the best evidence must be presented. So the best evidence should be preferred over relatively evidence which is not best, or which is better, or which is good, something like this. So there are two basic representation of this. I have given 4 illustrations here of this particular phenomena in law of evidence. One is documentary evidence is preferred over oral evidence. Why documentary evidence is preferred over oral evidence? Because documentary evidence is maintained more appropriately as compared to oral evidence. There is a possibility of lapse in oral evidence, but there is less possibility of lapse in documentary evidence. And that's why documentary evidence is considered best evidence as compared to oral evidence. Then documents are divided or categorized into 2 kinds of evidence. One is primary and another is secondary evidence. And primary evidence is preferred over secondary because primary is the evidence in which the original document is entertained before the court or brought before the court. But secondary evidence is a derivative kind of evidence, derivative from the original source. That is why it is termed as secondary evidence. So primary is the best evidence as compared to, and then public documents which are certified copies, they are encouraged to be brought before the court. Why? Because those documents which were preserved in the public offices, they are generally considered to be in safe custody. That's why their authenticity is relatively better established as compared to those documents which are not in public custody. And then the documents which are kept in official custody, there are number of presumptions attached to it. From Article 91 onward, we see that number of documents are mentioned there, and number of kinds of presumptions are there with respect to those documents, and generally they are presumed to be genuine unless something is there against those documents. No, we are okay on the topic of presumption, and then burden of proof. We are heading toward the conclusion. As when we started, we said that the Qanun-e-Shahadat order was based upon 3 principles, and we have enumerated those principles and how those principles are incorporated in various provisions of law of evidence. And the next part of the law of evidence deals with who has to brought the evidence before the court. So this area of evidence is generally known as burden of proof, dealing with burden of proof of the parties in evidence. And then there are presumptions, different kinds of presumptions are there in law of evidence. And on the basis of those presumptions, certain facts could be concluded. And those presumptions are of various kinds. If we survey the law of evidence, Qanun-e-Shahadat order, we will see that there are 3 kinds of presumptions mentioned in Qanun-e-Shahadat order. One is presumptions of fact, That is, there are a number of illustrations of this category of presumption in Article 129. All of those presumptions which are presumptions of fact, they are rebuttable. They are entertained as pieces of evidence, but their opposite party is always given an opportunity to produce evidence against those presumptions. And then there are some presumptions which are termed as presumptions of law, and illustrations of those presumptions are from Article 19 to 101. These presumptions are also rebuttable presumptions, and if we refresh the provisions dealing with those these two kinds of presumptions, when it is mentioned in the Qanun-e-Shahat order that the court may presume, that is presumption of fact generally, and when it is mentioned the court shall presume, that is presumption of law. But in both of these two situations, the presumptions are rebuttable in the sense that the opposite party has an opportunity to produce evidence against those presumptions to avoid any evil consequences. The third kind of presumptions are termed as conclusive presumptions, and this is a subcategory of presumptions of law, and these presumptions are irrebuttable. There are just two illustrations of this particular phenomena in the Qanun-e-Shahat order. One is in Article 51 and another is in Article 128, dealing with the legitimacy and paternity of children. Evidence, and it is a general principle of law of evidence, and number of provisions have reflected this principle, that the one who has asserted something, he is legally bound to prove that thing. So the burden of proof lies upon the person who asserts. In civil cases, assertions are made generally by the plaintiff. In criminal cases, assertions or claims are made by the prosecution. So the burden of proof generally lie upon plaintiffs and prosecutions in civil and criminal cases respectively. So burden of proof is also divided into two categories. One is known as legal burden of proof and another is known as evidential burden of proof. As far as the legal burden of proof is concerned, as we have stated, that this is upon plaintiff in civil cases and this is upon the prosecution in the criminal cases to prove the case. And then as far as the evidential burden is concerned, that burden is relative, that burden is likely to shift on the basis of evidence produced before the court. For example, if the evidence is produced before the court and that evidence appears to be relatively convincing, then the defendant is under legal obligation to rebut that evidence. If defendant doesn't rebut that evidence or bring evidence to contradict that evidence, the case would be decided against him. So what kind of burden is upon the defendant in this situation? This is known as evidential burden. For example, in criminal cases, the burden of proof is upon prosecution to prove the case beyond any shadow of doubt. But when the case is likely to prove in favor of prosecution and the accused is apprehensive that the case would be proved on the basis of this particular evidence, he is under evidential burden to rebut or to point out those discrepancies in the evidence presented by the prosecution. This burden is known as evidential burden, and evidential burden shifts from one party to another on the basis of quality and quantity and convincibility of the evidence produced before the court. So these are the two kinds of burdens which have been dealt in our provisions. Now coming to another concept of examinations. There are three kinds of examinations in law of evidence. Witnesses, when they are produced before the court, they are questioned by the attorneys or advocates in the court or the who are representing different parties. So when a witness is before the court and he is questioned by the party who has brought that witness in the court, this is known as examination in chief. As we have said earlier, that the plaintiff is under legal obligation to prove his case. So he has to brought the cases, witnesses, he has to brought the witnesses in the case to prove those facts. And when he brings the witnesses in his favor, and his attorney puts question to those witnesses, and these questions are kinds of examination is known as examination in chief. But when the opposite party starts questioning from the witness, this is known as cross examination. And then another kind of examination is termed as re-examination. Generally, the examination in chief and cross-examination is confined to the relevant facts. But sometimes in cross-examination, opposite party raises those issues which were not earlier raised in examination in chief. That's why the plaintiff or prosecution, the party who has brought the witness at the initial stage, he is given an opportunity to re-examine the witness after cross-examination. So the re-examination is the option given to the party who has already conducted examination in chief. In examination in chief and re-examination, leading question is not allowed. Leading question is the question which suggests its answer. So the question in which the answer is already implied or hidden, that question is termed as leading question, because these parties have to examine the witness on the basis of his memory, on the basis of his retention of evidence. And if they suggest something to the witness, that would be termed as leading question. But so far as the opposite party is concerned, that party is at liberty to ask leading questions. And this is what is mentioned in Article 135. But sometime a witness brought by a party turns hostile against that party, and this concept is there in Article 150. And for example, a witness, a prosecution witness started to give evidence against prosecution. So what prosecution expected when they brought that witness in, he is not giving that kind of evidence. So that witness is hostile witness, and he could be asked, and the prosecution in this situation is given opportunity to ask leading question from the witness, because that witness is hostile to them, and now they have opportunity to deal with um, him as if he was brought by the opposite party. So this is the concept of hostile witness. Last concept, and this concept is related to the reliability, the point which we made earlier, evidential value, as far as what we said when we started this presentation, that the law of evidence deals with relevant pieces of evidence. But how far those pieces of evidence possess evidential value, that has not been dealt in law of evidence. So that question is left open to the court to determine on the basis of quality of each and every piece. And similarly, who is a competent witness, that is something else. But how far that competent witness is reliable, that has not been specifically pointed out in law of evidence. So the question of evidential value, which the court has to determine, and one of the modes for determining this evidential value is the procedure of corroboration. Corroboration means that one piece of evidence is supported by another piece of evidence, that another piece of evidence corroborates the first piece of evidence. The first piece is primary evidence. Suppose we are using this term in a non-legal manner, that one primary piece of evidence is supported by another secondary piece of evidence. So the concept of corroboration was evolved during the judicial process, and there are many provisions in which this process is read into. For example, in Article 16, where we deal with the evidence of accomplice, his evidence must be corroborated, and this concept is judicially evolved. And when we read Article 3 dealing with the competency of witness, there are a number of kinds of witnesses whose evidence is not considered unless their evidence is corroborated by independent witnesses or independent pieces of evidence. For example, police officials, for example, child evidence, interested witness. So this concept of corroboration was developed basically to ascertain the value and worth of particular pieces of evidence, and court could use it its own discretion. And when we read law, different provisions of law of evidence, we see that it is mentioned that this corroboration is not a legal concept. This concept is applied for the purposes of caution. So this is a cautionary kind of principle which is applied, and so that a wrong decision might not be announced by the court to avoid from any lapse of justice. Court generally require that those pieces which appear to be convincing, but if they we have to give them a conclusive value, they should be supported from some other independent pieces. In this way, they are corroborated, and then the court feels relatively easy to pronounce a judgment. So this is the concept of corroboration, which is attracted in retracted confession, extrajudicial confession, dying declaration, and there are a number of provisions in which this is related into even in expert evidence is sometimes treated as corroboratory kind of evidence. So there are many manifestations of this particular kind of evidence. So that's it. Good luck for the exam. I have taken much time.
Thank you very much, Professor Chima. I think that was excellent, as always. Now we move on to our last session that would be led by Advocate Sara Raza.
Assalamu alaikum, everyone. Thank you so much, Dr. Zubair. I'll be covering the session on professional ethics, and let me just share my slides so that we can begin. Can everyone see my slides? Yes. Am I audible?
Yes, 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 you are.
Great. Thank you. So one of the last topics of our law GAT every year is professional ethics, and what the HEC basically tests potential advocates on is the Pakistan Legal Practitioners and Bar Council's Rule 1976. And for that, they basically just want the advocates to know and be very well versed with Chapter 12 of the rules. And the Chapter 12 basically covers canons of professional conduct and etiquette of advocates, and the rules are from 134 to 175B. So there are 10 MCQs in total on the exam on professional ethics, and this chapter basically just discusses the duties and responsibilities of advocates in Pakistan. There are some tips that I actually want to share with all of you, because when I appeared for the law GAT, I realized that these were things that we did not know. So it would be helpful if you can just focus on learning this topic or studying this topic by keeping these tips in mind. So you should learn all the provisions, that's a given, but you should also learn like the rule numbers that are of the provisions. So like if there are 10 MCQs, I remember almost there were like 8 questions that asked us that this is the provision and which rule number stated this provision. So 134, 135, 136, 137. It was like this. So it's good if you make a mental note, if you make a mental note of which rule lies under which subheading, and we'll be discussing the subheadings just in a while. And this will help you recall the rule numbers with the title of the heading given in the rules. You should, of course, try to write and learn so that when you like make a table of the rules and the rule numbers, it sticks in your mind that if this was the rule, this was the provision or section number where it comes from. You may also try attempting the professional ethics section in the beginning, right in the beginning of the exam, so that you don't forget the rule numbers that you have remembered and learned. And on the day of the exam, you just need to, before going into the test center, you need to revise and revise so that you don't forget and lose out on the easiest number, like easiest scoring part on the exam, which is why it's so necessary to revise the rule numbers and the rules. So chapter 12 is the canons of professional conduct and etiquette of advocates is divided into 4 sections. Part A basically is about conduct with regard to other advocates. Part B is conduct with regards to clients. Part C is duty to the court, and Part D is conduct with regard to the public generally. You can see that these rule numbers are written in front of each section, and I will be moving forward with each section, but won't be covering each and every rule in detail. Will be briefly giving you a summary of what each part talks about. So conduct with regard to other advocates, part A is basically telling you how it's so necessary and important for every advocate, and there's a duty on every advocate to uphold the dignity and high standing of the legal profession, not just of the profession, but also himself as a member of that bar council of that profession. So an advocate is also not to discuss any subject of controversy with any party unless they have the permission of the advocate of the opposing party, or if the opposing party's advocate is absent. The advocate is also not supposed to communicate with a judge or judicial officer in the absence of opposing counsel. An advocate should also decline association as a colleague unless the dues of the first advocate who was engaged are paid. Any ill feeling, any fight, any quarrel, anything between two different parties are not supposed to affect or influence the relationship between the advocates that are from the opposing sides or opposing counsels. And juniors and seniors are also supposed to be very courteous, helpful, and respectful to each other. Moving on, you will see that part B basically discusses conduct with regard to clients. Advocates are not supposed to acquire interest adverse to their client in the property or any interest involved in that case. Advocates are also not allowed to accept any employment adverse to a client or a former client relating to a matter in reference in which like he or she has obtained confidential information, because that is just that just leads to more conflicting interests. An advocate must not accept professional employment unless they disclose if there's any relation they had with adverse parties. So you cannot, as an advocate, accept that professional employment, which means accept a case unless you disclose that you had an adverse interest with a party of the same case with an adverse party. You had an interest with an adverse party. And an advocate should not represent any conflicting interests. Like we discussed before, an advocate is also not supposed to advise on the commencement of prosecution or defense unless they have been consulted for the same and asked about it. An advocate must also not advise any violation of law unless it's in good faith and they know that, and they believe that the law is invalid. Any fees that is charged by the advocate should not be overcharged, should not be undercharged. It should be accurate and according to the services that they are providing. C, duty to the court. So an advocate is supposed to maintain respectful attitudes toward the court and show the bench its supreme importance. An advocate must not advise a person who is supposed to give testimony and appear in court to avoid service of process or conceal himself or not make his testimony available. An advocate should also not misquote to a judge or a judicial officer any testimony of a witness, any argument of an opposing counsel, any contents of the document whatsoever they may be. An advocate is also not supposed to communicate or argue privately with a judge or a judicial officer with regards to the merits of a pending case. And an advocate is not supposed to engage in public prosecution to convict, but actually to see the justice is done. And furthermore, an advocate should not volunteer his legal opinion in a court unless he's asked to do so. And if he does this, he should do it with a sense of responsibility and impartiality. Part D of the rules, 1976 rules, state conduct with regard to the public generally. And an advocate should not accept employment or should not engage in prosecution or defense just to merely harass someone or delay the matter. An advocate should not treat adverse witnesses or parties with disrespect. They should be extremely fair and which should deal with parties with due consideration. Advocates are also not allowed advocates are also not supposed to be bound to take up all and every case that they are asked to take up. They have a right to decline professional employment, and they are not obliged to take any clients that may come their way. Advocates must not communicate with or appear before a public officer, a body, a board, a committee, until they disclose their interest and their identity in the professional capacity, telling the so-and-so officer, board, committee, or body that the decision they take might affect the interest that the advocate is representing. And finally, an advocate must not accept employment as an advocate where he or she has previously acted in a judicial capacity or been a judicial officer. So these were the professional ethics rules, and you should definitely go to the 1976 rules and read all of them. And like I said, make mental note of the rule numbers that are there so that it can help you easily score on that part of the law GAT exam. Thank you.
All right, with this, we come to the end of our session, and I wish all the participants good luck for their exam. And I thank all the instructors who participated in this session for their contribution. And if you have any questions, if you want to provide us feedback, please get back to us. We have shared with you Law GAT handbook. Please feel free to use it and share it with everyone and provide us feedback on this. Also, it's an ongoing project. We shall try to make it better. And with this, Allah Hafiz and take care.